It's unmuted.
All right, good morning, council. Hope everyone can see and hear me okay. I'm going to start calling the morning docket. I've got several people in the waiting room. In a moment, I'm going to go ahead and do a plea with Mr. Files, Mr. Cruz, and then after that, I'm going to ask each one of you for just a brief announcement before we bring your clients in. One, for me to confirm if your client's in the waiting room, and if so, then we'll just bring them in at that time. But I kind of want to get my hands around who's going to be ready and whose clients are in the waiting room. So as soon as we finish with Mr. Files, then I'll start calling on you individually. All right, Mr. Files, I'm going to prompt you to, if I can find you here in my, there you are. All right.
Yes, Your Honor.
Can you see and hear me okay?
Yes, Your Honor, we can.
All right. All right. Good morning to you, sir. How are you?
Good morning, sir. How are you?
Doing fine. Doing fine. All right. Are you ready, Stella? This is cause number CR 21-43, State versus Camden Cruz. Mr. Cruz, I'm going to ask that you raise your right hand so I can place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
You can put your hand down. Make sure that you speak up for me today. I have a court reporter in the courtroom who's going to be taking down everything that we say. Make sure that you don't talk over me or your attorneys, okay?
Yes, Your Honor.
All right, Mr. Cruz, are you a United States citizen?
Yes, Your Honor.
Do you read, write, and speak English?
Yes, Your Honor.
Have you ever been diagnosed with any type of mental condition?
No, Your Honor.
And in your case by your attorney, Mr. Buck Files, are you pleased with his representation of you?
Yes, Your Honor.
Mr. Files, are you the lead attorney on this case, or is it Mr. Harrison? I have Mr. Harrison's name on the case.
Oh, I'm lead on it.
Okay. All right. And Mr. Cruz, do you feel like you've had enough time to speak with Mr. Files and Mr. Harrison about your case to have all of your legal questions answered?
Yes, Your Honor.
Is there anything about the plea agreement that you do not understand?
No, Your Honor.
All right. And Mr. Files, you've explained your client's legal and constitutional rights to him.
We have, Your Honor.
And
We've also reviewed the tape. We've looked at the search issue in the case. There's no meritorious basis for filing a motion to suppress. And I'm satisfied that this is the best route for him to take.
Thank you, sir. Do you believe him to be competent today?
Yes, sir. No issue as to competency now or sanity on the date of the offense alleged.
Okay. I see here that Mr. Cruz was originally indicted by the grand jury with a third-degree felony offense of possession of a controlled substance. However, it appears that the plea agreement before the court today is that Mr. Cruz would be pleading guilty to a Class B misdemeanor offense of possession of marijuana less than 2 ounces. And I believe that this is a new cause number, CR 2143. So it looks like the state's going to be dismissing that originally indicted charge and has filed an information in CR 2143 alleging possession of marijuana less than 2 ounces. And that Mr. Cruz is going to plead guilty to that. And the state's going to recommend to the court that a finding of guilt be that he be placed on community supervision for a period of 1 year, that he be assessed a $1,000 fine. And the state is going to be dismissing CR 2295, that possession of controlled substance F3 charge. In addition, there would be $270 court cost and $15 reimbursement fee. Mr. Files, is that your understanding of the plea agreement?
It is, Your Honor.
All right, and yours as well, Mr. Cruz?
Yes, Your Honor.
All right, then, Mr. Cruz, I'm going to ask you at this time, do you understand that the full range of punishment for a Class B misdemeanor offense is confinement in the county jail for a period up to 180 days and a fine not to exceed $2,000? Do you understand that if the court approves this plea agreement today and I place you on community supervision, if you violate and the state proves that to the court could revoke your community supervision, assess your guilt in this charge, and could sentence you up to 180 days in the county jail? Do you understand that?
Yes, Your Honor. I understand.
All right, Mr. Cruz, I'm going to ask you at this time, how do you plead to the Class B misdemeanor offense of possession of marijuana less than 2 ounces?
Plead guilty, Your Honor.
And Mr. Cruz, are you pleading guilty because in fact you are guilty of that offense, no other reason?
Yes, Your Honor.
Has anyone threatened you, forced you, or pressured you to plead guilty to this charge?
No, Your Honor.
All right, the court accepts the defendant's plea of guilt. Mr. Files, is there any objection to States 1, the stipulation of evidence?
No objection to the exhibits is marked and offered, Your Honor.
All right, court admits States Exhibit 1 and takes judicial notice of Mr. Cruz's judicial confession. Is there anything further from the state?
No, Your Honor. State would rest and close.
Anything further from the defense, Mr. Files?
Your Honor, I think we have worked out a glitch. Ms. Curry and I have been discussing this case for months and months and months. And it was our understanding that we needed to be here to meet with probation because his case was going to be transferred to Florida for supervision. Our client met with Mr. Gann today. Mr. Gann was his usual pleasant self, but explained to our client that he could not be transferred. I've got Ms. Curry here who says that it is set to be transferred. So Tonda, can you tell the judge where we are?
Yes, Your Honor. I think the court is aware that the receiving state has to accept and probation cannot commit to the fact that they will accept. They don't see any reason they wouldn't. But until he is accepted, or in the event that he's not accepted, they would agree to mail-in reporting and appearing in person only once every 3 months.
Ms. Curry and I had originally talked about that, and we've explained that Florida has to accept him before it can be done. But if we go into the understanding that between now and then he's to report by mail for the first 2 months and then report in person on the third month if Florida has not accepted him or if they choose not to accept him.
That's correct, Judge.
Okay, thank you.
Also, on behalf of Mr. Cruz and his mother, we're deeply appreciative of the court hearing us first where they can get back to Dallas and get on a plane to go back to Florida. They had a real tight squeeze on reservations.
Yes, sir. You're very welcome. All right. Based on the court's review of the evidence, court finds that there is sufficient evidence to convict Mr. Cruz of this offense. However, the court will follow the plea agreement in this case. Court hereby defers a finding of guilt, places Mr. Cruz on 1 year community supervision, assesses a $1,000 fine. The court dismisses CR 2295 under section 1245. Court also assesses court costs of $270 and reimbursement fees of $15. Mr. Files, do you know how your client intends to handle the financial obligations?
We're going to send him down to make arrangements on a payment schedule.
And have you spoken with Mr. Cruz about his failure to pay his financial obligations, how that could result in a violation of his community supervision and also the court issuing a warrant for a KPS pro fine?
Mr. Cruz understands that he is obligated to each and every jot and tittle on the conditions of probation, and he will make his payments timely, I'm certain.
Okay. Just one moment. All right, Mr. Cruz, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department. And Mr. Cruz, what I'm going to do is have you have a seat out in the hallway, and Ms. Burns, the director of our Community Supervision Department, will come and retrieve you in just a moment and give you additional information regarding your probation, okay?
We had him at the probation office at 8 o'clock this morning. He's already gone over a number of things, so he'll be waiting to see her.
Okay, yeah, and she's present here, so she'll be out there in just a moment.
That's all the business we have before the court. May we be excused?
Yes, thank you, Mr. Files.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome.
Good morning, Judge.
Judge, you're muted.
That's my line, Mr. Weiner. That's the last time you get to say that today.
I'll try again later.
You just let me talk for 20 minutes muted, okay, next time.
You got it.
Thank you, Mr. Weiner. Appreciate it. All right, I'm going to go down the docket here. I'm going to tell you who I see in my waiting room and then make sure that both attorney and client are ready. That way, those of you who do not hear your client name called, you can get on the phone and find out where they're at, okay? So let's see here. I'm going to start with, okay, Mr. Ashmore. I do have Miss Fowler, so I know she's ready to go.
We're ready, Judge.
Mr. Calabria, do you have your client, Mr. Anthony, with you?
Yes, sir. He's present in our office.
Thank you. And counsel, if you have your client with you, you let me know.
Yes, sir, Your Honor. Ms. Mark Calabria, our client's present in our office with us.
Okay, yes, sir. Thank you. I'll mark you down.
Okay, thank you.
All right, Mr. Gimbel, Sable Burgess is in my waiting room. That one will be ready.
Yes, spoke to Ms. Burgess this morning. We were ready to go forward.
Okay.
And I spoke to Mr. Carl Klump yesterday evening. He has. the
Yeah,
copy.
I'll tell you what, Mr. Gamble, I'm just going to go down and check off who I have, and then we're going to call. So give me just a moment. I'm just going down my docket here and trying to figure out who's here and who's not here. All right, Mr. Lloyd, I have your client, Mr. Gross. I believe I have Taylor Godfrey. Let's see, Taylor Godfrey for Mr. Waldron. Are you here on behalf of Mr. Parrish?
I am, Judge. And Judge, not to try to jump anyone, but I've got federal court at 10 o'clock that I need to get to. So I think our announcement's going to be an agreed pass.
Okay. Wait with you just a moment. And Mr. Robertson, I have Mr. Thompson. He's going to be available. And then William Ivy, Mr. Schmidt. I believe I've seen Mr. Ivy. Yes, Mr. Ivy's ready to go. Jacqueline Jacobs is also ready to go. Kimberly Marshall is ready to go. Mr. Steele. Stormy McCoy, I have Mr. Steele. Michael Watkins, Mr. Steele. Eric Atkinson, Mr. Stevens.
Yes, sir. We're ready, Your Honor.
I do not see your client, Leslie Gibson, though. And, another individual, Leonard Williams, is in the courthouse. He'll be ready in just a moment.
Judge Kobe Cole is one of mine, and this is Kyle Steele. He said he's on as well.
Yes, he is, and I filed there's a dismissal filed on that, and I signed that yesterday. So I'll bring him on in just a moment.
Thank you, Judge.
Who has Karen Burton?
I do, Your Honor.
Okay, so Mr. Green, Karen Burton just logged in, so I have Karen Sue Burton available also. Bring Mr. White in. Who has Holly Mormon? Mr. Head?
I do.
Head? Okay.
I do,
Holly.
Judge.
Okay, she's available. So I think that's. And have I called Kimberly Marshall? Who has Kimberly Marshall?
Judge, that's Mr. Steele.
I'm sorry, Judge. Yeah, that's me. And
Okay, and I've already called her name.
yeah,
What about LaDon Munn? MUNN. Anyone have LaDon Munn? Okay, that's Jeff White. All right, so I got Mr. White. And I do, if I haven't called your client's name, I do have an unidentified lady in the waiting room. We've tried to get her to connect, can't get her audio to connect, and she doesn't have an ID on her screen, so I can't tell you who she is.
Your Honor, that may be one of my client's mother. She's just attempting to view. That's my understanding.
Okay. Well, I won't be bringing anybody into view. They can view it on the court's YouTube channel. I won't bring them in the hearing though. Just so that you're aware.
That's fine, Judge. I just, I believe he indicated to me that she wanted to view it, and I told him that I would let the court be aware of that.
Okay. All right, Mr. Waldron, since you asked to jump ahead of everybody, we'll go ahead and call CR 20337 State versus Taylor Godfrey.
Judge, it's my understanding that an offer has been made in that case, and we anticipate resolving that with a plea. But Mr. Parrish needs additional time to meet with his client and confirm that's in fact the way this case is going to be resolved. So we do have an agreed pass to allow us to complete the plea negotiations in this case.
What about the discovery issues? Are there any? Today was a pretrial setting for Mr. Parrish to file any contested pretrial motions. Do you know if he's filed any of those?
Judge, we probably filed standard motions, but there are no contested issues we're raising at this time.
Okay, so what the court will do is I'll set this for docket call, and that will give Mr. Parrish the time that he needs to continue negotiating with the state, if that's the route. And so I will set this, Mr. Parrish's calendar at all, Mr. Waldron?
Yes, Judge.
Okay. Would he be available on Today is the 23rd. Will he be available on Tuesday, March 23rd?
Yes, Judge, he will be available that day.
Right, and let me see if. All right, Mr. Godfrey, raise your hand if you can hear me. All right, thank you, Mr. Godfrey. All right, so keep your phone still for me there. All right, I'm going to unmute you here. I'm going to prompt you to unmute. I want you to accept that on your phone. All right, Mr. Godfrey, can you see and hear me okay?
Yes, sir, I can.
All right, I'm not sure if you can see or hear Mr. Waldron. Mr. Waldron's an attorney who is standing in for your attorney, Mr. Parrish, and we have set your case for docket call on March 23rd so that Mr. Parrish can continue working with the state to see if they can resolve your case. So I'm ordering you back before the court on March 23rd, and you will appear via Zoom unless otherwise directed by your attorney or the court. And you stay in contact with Mr. Parrish and he'll give you the Zoom ID for that court. You understand?
Okay.
All right, so
Yes,
this will be the only notice that you get, March 23rd at 9 a.m.
Okay.
All right, you're free to go.
Thank you,
All
Judge.
right, thank you, sir.
You're welcome. Thank you. Thank you, Mr. Waldron.
Bye.
All right, Mr. Green, are you ready on Burton?
I am, Your Honor.
All right, let me get your client here and bring her in. She's connecting. All right, while we're waiting for Miss Burton to connect, in case that she doesn't. Oh, there she is. Here we go. Miss Burton, I'm going to prompt you to unmute your phone.
Is that,
Yes, ma'am, that's better. Can you see and hear me okay? This is Judge Chris Martin.
yes, sir.
All right, and Miss Burton, if you can't see your attorney, Mr. Green, there's a lot of attorneys involved in the hearing. You may have to swipe left or right to see him, but I can assure you that he's present in the courtroom today. And this is cause number CR 20-324, State versus Karen Sue Burton, set for pretrial. Go ahead, Mr. Green.
Judge, I'm going to ask the court to pass this pretrial. I was scheduled to pick up the video in Miss Burton's case, or I planned to pick it up last week in order to review it and determine whether any pretrial motions needed to be filed. Obviously, the weather didn't cooperate with that. I have all other discovery. I just needed an opportunity to view the video and decide how to proceed after doing that.
All right, court will set Miss Burton for pretrial. Are you available on Tuesday, March 23rd?
Yes, sir. In the morning?
Yes, sir, at 9 a.m.
Yes.
via Zoom. All right, Miss Burton, you're ordered to be back on Zoom in this court on March 23rd. Mr. Green will have the Zoom ID number for you. Stay in contact with your attorney, and this will be the only notice that you get. You understand?
March the 23rd?
Yes, ma'am. March 23rd at 9 a.m.
Yes, sir.
All right, you're free to go.
And Your Honor, that's all my business. May I be excused?
Yes, thank you, Mr. Green.
Thank you, Judge.
All right, Mr. Calabria, you're on mute. See, that's my favorite line. You're still on mute. I'll second Fairline. Here, let me do it for you. Don't touch anything. Don't touch anything. Now try it.
There we go.
There we go. All right, here we go. This is cause number CR 17-77, State versus Jerry Edward Anthony Jr. And we are set on a motion to adjudicate. Any announcement, Mr. Calabria?
Yes, Your Honor. I think by agreement, we'd like to ask the court to reset the state's motion to adjudicate. Spoke to Ms. Heisel yesterday, and the state's communicated a new plea offer to my client. We've not had a chance to discuss it, but that's next order business for us today. And I understand if we require a hearing, a live hearing on the motion, that we have to request that from the court. I don't know what the timeline for that is, but I'm hopeful that we'll resolve this in a plea agreement, and that won't be necessary.
Any opposition from the state?
No, Your Honor, I did just make that offer yesterday, so I think that that's a reasonable timeline from Mr. Calabria.
All right, so you asking the court to set it for a non-contested hearing, or just go ahead and set it on a contested date so that if it's rejected, we can have some movement on the case?
That would be my preference, Your Honor, but I defer to Ms. Heisel.
Yeah, I'm fine with whatever the court wants to do. I think we can go ahead and set it for contested. I believe the state's made their best offer, so if he doesn't want to accept it, then I think a contested hearing is the next option.
All right, Mr. Anthony, the court's going to set you for March 30th. Are you available on that date, Mr. Calabria?
Yes, Your Honor.
Okay, so we'll set this for a contested hearing on March 30th at 9 a.m. And that will be via Zoom. If there's a request to appear before the court, you'll need to file that with the court, and the court will have to make findings. And the court can do that, but it has to be requested by the party first. So March 30th will be the contested date. Mr. Anthony, what that means is if you and the state do not resolve your case by agreement, then on March 30th, the court is going to hear the state's evidence and make a decision in your case. All right, so this will be the only notice that you get. Stay in contact with Mr. Calabria. He'll have the Zoom ID number for you for that date. Do you understand?
Yes, sir.
All right, you're free to go. Thank you.
Thank you, Your Honor. It's all our business. May we be excused?
Yes, sir.
Thank you.
All right, Mr. Weiner, are you on Ms. Mormon?
Yes, Your Honor. She's in the waiting room.
Yeah, let me go find her here.
Thank you.
All right, good morning, Ms. Can you see and hear me okay?
Yes.
All right, your attorney, Mr. Weiner, is present in the hearing also. If you can't see him, you may have to move left or right on your device until you do. This is cause number CR 16-139, State versus Holly Elise Mormon, and we're set on a motion to adjudicate today. Mr. Weiner, go ahead.
Yes, Your Honor. I spoke with Ms. Heisel yesterday. This was a case that was previously handled by Mr. Cox. I had not received an offer until yesterday, obviously at my request. I have a kind of a tentative counter offer that requires my client to do some checking into some.
Hang on, can you repeat that again, Mr. Weiner? I didn't pick up any of that.
Oh, okay. This was a case previously handled by Mr. Cox, and Ms. Heisel has taken it over. She had made me an offer yesterday. And I have essentially a tentative counter offer that requires my client to do some history or research with her health insurance or potential treatment options for me to relay that to Ms. Heisel. And so we have an agreement to pass the case with the court's approval.
All right, what I'm going to do is the same thing I did Mr. Calabria's case is I'm going to go ahead and set this for a contested hearing on March 30th. You have any scheduling conflicts that day, Mr. Weiner?
I'm sorry, it's real patchy, Judge. Did you say March 5th?
March 30th, March 30th.
As long as it's in the morning, that'll be fine.
All right, court will set this for a contested hearing on March 30th at 9 a.m. And if there's an agreement reached between the state and the defendant before then, you can contact the court and we can get you set on a different docket sooner if that needs to be the case.
Thank you, Judge. That's all we have. May we both be excused?
Yes, and Ms. Mormon, you understand you're still on probation. You're still required to report, follow all your conditions of probation, and you're ordered to be back before the court on March 30th at 9 a.m. via Zoom. Stay in contact with Mr. Weiner or Mr. Head. You understand?
Yes, Your Honor.
All right, you're free to go.
Thank you,
Thank
Judge.
Thank you, Mr. Weiner. All right, Mr. Robertson, are you ready on Mr. Jameel Thompson?
We're ready, Your Honor. We have an announcement to make to the court.
All right, let me get him pulled into our hearing. If I can find him.
I called and he said he was on.
Oh, he was on earlier, yes. There's a bunch of people in here. Just got to go through my Rolodex here.
Judge, I apologize. He's our Aristo 4+.
Oh, I thought you had that fixed earlier.
I did, and I guess he logged off and he's come back in and didn't use his name.
Thank you, Ms. Barker. I appreciate that. Well, we had him set up earlier, but looks like he's, there you go. Mr. Thompson, can you see and hear me at all? Raise your hand if you can hear me. Yeah, Mr. Robertson, my coordinator, walked him through everything earlier and had him set up. And
Judge, if you want to, I could just hold on and you can go ahead and do someone else till they get it straightened out.
okay, let me do this. I'm going to put you and Mr. Thompson in a breakout room real quick.
Yes, Your Honor.
Then maybe you can walk him through it and then just return to the hearing when you're ready, okay?
Yes, Your Honor.
All right, give me just a moment. Mr. Schmidt, I'm going to call your clients next. Be ready. All right, Mr. Schmidt, let's see. I'm going to call Mr. Ivy. Are you ready on Mr. Ivy?
Yes, sir. We're ready.
Let me bring him in. Looks like he's about to connect to audio. All right, Mr. Ivy, I prompted you to unmute. Can you see and hear me this morning?
I can hear and see you now.
All right. Mr. Ivy, your attorney, Mr. Richard Schmidt, is present in our hearing. There's a lot of attorneys in this hearing. You may have to move left or right if you want to see him.
Okay.
Mr. Schmidt, this is State versus William Dwayne Ivy, CR 19, 313, 314, 315, and 316. All cases set for pretrial on my docket. Any announcement?
Yes, Judge. We have received the discovery from the state. I believe we've got it all. We're going to ask today for an additional pretrial setting and discuss with the state. Ultimately, Mr. Ivy has undergone surgery. I've undergone surgery, and then we had a weather event that has prevented us from getting together and going through discovery together. And I think it's critical that we do that prior to having a pretrial. So we'd ask that that be set off for an additional pretrial.
Any objection from state?
No, Your Honor.
Mr. Schmidt, are you available on March 23rd?
Yes, sir.
All right, the court's going to set each one of these cases for an additional pretrial on March 23rd at 9 a.m. Mr. Ivy, you'll appear via Zoom again that day on March 23rd at 9 a.m. And you need to stay in contact with Mr. Schmidt. He can give you the Zoom ID number for court that day. Do you understand?
Yes, sir.
All right, Mr. Ivy, you're free to go.
Okay, thank you, sir.
All right, I'm going to attempt to bring in Jacqueline Jacobs. Well, it looks like Miss Jacobs is not able to turn her device on. I'm going to try to go back to Mr. Robertson's client.
It should work now, just explain it to him. We'll see.
All right, I prompted him to return. All right, thank you, Mr. Robertson. All right, Mr. Thompson, I prompted you to unmute. Okay, can you see and hear me okay this morning?
Yes, sir. Yes, sir.
All right, Mr. Thompson, let me put your name in your device real quick. So moving forward, I want every time you log in, Mr. Thompson, I want you to put your name in so that I will know who you are. And so I'm going to try to figure that out, okay?
Okay.
All right, this is cause number CR10-176, State Jameel Mustafa Thompson, and we're set on a motion to revoke today. Any announcement, Mr. Robertson?
Yes, Judge, this is the case I was working on with Danny Cox. I got in touch with Hillary yesterday and discussed this case with her. This was the situation, if the court will remember, Mr. Thompson probation expired on August 4th for 2020. It was the issue of money, and we're trying to get that money paid off. I talked with his SSI attorney yesterday, Rebecca Henderson. She said, hey, Clifton, he has a hearing. I can't tell you when the hearing date is going to be set. She said, most likely it's going to be about 6 months. And I said, hey, look, 6 months is a long time, and I doubt the court can hold off for 6 months. But the judge, it was a situation where he owes like $8,000 in attorney fees, court fees, and additional fees. And also he turned over some additional medical records to the probation department. It's however the court want to approach this, judge. We're trying to get that money. However, she said she can't have a hearing until another 6 months because there's a backlog in the SSI case, Your Honor.
Is he making payments to the probation department now?
He has no income. And she was saying that, hey, look, he's going to probably be approved. It's just that they got that long waiting list before they can have hearings. He will get back pay, but he has no money at this time.
State, what's your position?
Judge, I did speak with Mr. Thompson's probation officer yesterday, and she did confirm that he has had some significant medical issues and has provided her documentation to confirm all of that. She's going to send it to me. When Mr. Robertson and I spoke yesterday, I didn't realize we were on a 6-month timeline. I don't think he did either. If we could just reset it 30 days to give Mr. Robertson and I to discuss what the options are. Obviously, I'm sure the court doesn't want to wait that long. And given the age of the case, I think we need to come up with a different solution. So I'd ask for a 30-day reset to be able to work something out.
That would be fine with me. That's okay with the court.
All right, Mr. Robertson, are you available on March 23rd?
Sure, Judge.
All right, let's come back on the 23rd and get an update on if there's any other resolution, because yes, that is, the court's not going to reset it for 6 months. I am willing to work with both the defendant and the state and getting Mr. Thompson into compliance with his community supervision, but 6 months is a long time. So we either need to get that paid or abandon the motion or come up with a resolution somewhere in between.
Yes, Your Honor. Is that 9 o'clock on March 23rd, Your Honor?
Yes, sir. 9 o'clock, just like today on March 23rd. Mr. Thompson, you need to stay in contact with your attorney and he'll have that Zoom ID number for you. You'll log in, you'll put your name in there and you'll just wait. Okay?
Okay. Okay.
All right. Anything else, Mr. Robertson?
No, Your Honor, that's it. And I appreciate it. I guess I can leave, just push leave, right?
If you have a leave button, then you got an extra button that I don't have. But yes, you're free to go.
Thank you, Your Honor. I appreciate it.
You're welcome. Have a good day.
Yes, Your Honor.
All right, Mr. Schmidt, we're going to speak with Ms. Jacobs. I prompted her to unmute. Ms. Jacobs, if you can unmute your phone now. All right, Ms. Jacobs, can you see and hear me okay?
Yes, sir.
All right, this is Judge Chris Martin. We are in court. This is CR 2255, State versus Jacqueline Elaine Jacobs. And Mr. Schmidt, your attorney, is present in our hearing today. If you can't see him, you'll just need to move left or right on your device. Mr. Schmidt, I believe we're set for a docket call today. Is that correct?
That's correct, Judge. We received an offer from the state, which we're going to accept. We'd ask that this case be set for a plea.
You available on March 23rd?
Yes, sir.
All right. Court will set Ms. Jacobs for a plea then on March 23rd at 9 a.m. Ms. Jacobs, you stay in contact with Mr. Schmidt. You'll appear via Zoom that day unless you are given different instructions by your attorney or the court, okay?
Thank you.
All right, you're free to go.
Thank you.
You're welcome. Is that all you have today, Mr. Schmidt?
I think it is, Judge.
All right, free to go. Thank you, sir.
Thank you. Have a good day.
Mr. Elliott, you ready on Mr. Caldwell?
Yes, Your Honor.
All right, so Mr. Caldwell, I'm going to prompt you to unmute. If you'll just click that button. There you go. This is CR 20-325 State versus Jeffrey Ryan Caldwell. And Mr. Caldwell, can you see and hear Mr. Elliott? Can you say yes or no? I can't hear you.
Yes, sir.
Okay. All right, I have a court reporter with me and she can't take down yes and no's with head shakes. You have to say yes or no. You understand?
Yes, sir.
All right, Mr. Elliott, we're set for pretrial today. Did you file any contested pretrial motions in this case?
No, Your Honor. I spoke with Ms. Heisel yesterday, and I've also talked with my client and Mr. Caldwell. Please correct me if I'm wrong. I believe that we have an agreement, and it's just a matter of a quick reset so my client can have an opportunity to fully review the agreement and ask me any questions.
Correct. Yes, sir.
All right, so the defendant wants to set this for a plea?
Yes, Your Honor.
Okay. And would March 23rd be enough time for you and Mr. Caldwell to get together to do that?
Yes, Your Honor.
All right, then the court will find there's no contested pretrial motions and we'll set this for plea. Mr. Elliott, you know the next question. Are you available on March 23rd?
Yes, Your Honor.
All right, Mr. Caldwell, you're due back to plea before this court on March 23rd at 9 a.m. You'll speak with Mr. Elliott and he'll walk you through what you need to do regarding the paperwork and how to appear on that day. Do you understand?
Yes, sir.
All right, you're free to go.
Thank you.
May I be excused, Judge?
Yes, thank you, Mr. Elliott. Appreciate it.
Have a good day, sir.
You too. All right, Mr. Lloyd, I'm attempting to bring in.
Yes, sir.
Let's see, while we're waiting on Mr. Gross to join, Mr. Austin, I don't know if I've seen your client. You just have one today, is that correct?
Yes, Your Honor, and he's here with me.
He is with you? Okay.
Yes, sir.
All right, I'll call you next, okay?
Yes, sir.
I'll tell you what, Mr. Gross is still trying to get connected. Let's go ahead and we'll go with yours, Mr. Austin, since this is cause number CR 2370, State versus William Bradley Stevenson. And we're set for pretrial today. Mr. Austin, do you have any contested pretrial motions on file?
I don't, Your Honor, and I don't necessarily expect any at this time. Spoke with the state yesterday, got an initial offer from them. May have one discovery issue on the case to get some lab results on this is a vape pen. I know that the evidence was submitted, but I don't see any results back from DPS on it.
Any announcement from the state on the discovery issue?
Judge, this is one of Mr. Cox's cases. I did speak with Mr. Austin yesterday. I was unaware that there was not a lab that had been turned over. If we could have just a few minutes so I can look into that, I can report back to the court just so we don't hold up the docket.
And Judge, I didn't bring that up yesterday with the state. I noticed it after we spoke on the phone.
So what you're telling me is that there's no lab in your discovery?
There's a DWI with it. I have lab results for that, for alcohol, but I don't see any results for THC.
Okay, we'll give Mr. Woodwalk a chance to review that. I'll recall that case in just a moment.
Yes, sir.
It's like we have Mr. Gross with us now. Mr. Lloyd, Mr. Gross, I'm going to prompt you to unmute. Accept that on your device there. Very good. Mr. Gross, can you see and hear me okay?
Yes, sir.
All right. Your attorney, Mr. Lloyd, is also present with us today. If you can't see him, you may have to swipe your device left or right, but I can assure you that he is present in our hearing. Mr. Lloyd, let's see. We are set for docket call today. Is there any kind of resolution on Mr. Gross's case, or are we going to be requesting a trial?
No, Your Honor, I still believe that we're going to be able to resolve this. I'm sorry, can you hear me?
Yes, sir.
Yeah.
I can hear you.
I was speaking with the state as of yesterday. I'll be honest with you. I have only spoken with Ms. Curry about this case. I have not spoken to any of her assistants. I will inform the court. I do believe that we're going to be able to get it resolved. I would just simply ask that it be, well, I just did not hear back from her yesterday. So, and the week before, obviously, we've had some issues as far as weather. Judge, we would just simply ask that it be, and I don't believe there's any disagreement with that they simply allow us to go to another docket call. I believe we've gotten all the discovery that they have. There was some issues regarding a potential second charge, which I've not heard from Ms. Curry about. So that's one thing that I wanted to make sure that we get resolved. Obviously, I want to be able to take care of everything at the time, but irrespective, I do not believe it's going to take the necessity of a jury.
Any objection from the state on Mr. Boyd's request for an additional docket call?
No, Your Honor, I spoke with Ms. Curry yesterday on this case. We do have an agreement in chief. I believe the issue of restitution is the only thing that hasn't been discussed with Mr. Lloyd. So I think a short reset would resolve all of the issues.
Thank you,
Mr.
Judge.
Lloyd, you available on March 23rd?
Yes, sir.
All right, court's going to set this for an additional docket call on March 23rd at 9 a.m. Mr. Gross, you're going to appear via Zoom again that day. Contact your attorney and he'll give you the Zoom ID number and you'll log in today. You'll log in then just like you did today. You understand?
Yes, sir.
All right, Mr. Gross, you're free to go.
Thank you, Your Honor. That's all I have. May I be excused?
Yes, sir.
Thank you.
Judge, on Mr. Austin's case, there is a lab in our system. I believe it was sent to him, but with these such things, there's no way to be sure. We resent it. If Mr. Austin still doesn't have access, I'd be happy to email it to him as well, so he can have a copy that way as well. I believe he's asking for a reset. State would not be opposed to that, so he has a chance to review that with his client, go over their options.
All right, so do we have any issue though with any contested motion?
No.
Okay.
No.
Well, let's do this then. Let's set it for a docket call and that'll give you time to review that lab and discuss any possible resolutions with the state. You available on March 23rd, Mr.
Yes, Your Honor, I am.
And I'm sorry, is your first name, it's Zachary Austin, correct?
Legally, yes, Judge. I just go by Zach. But that's
Okay.
fine.
Well, the reason I ask is because it's backwards on my docket. We've got first name, then last. And
Oh, okay.
you appeared at the bottom. I was looking for you at the top of the docket.
Okay.
Instead of the last. So I just wanted to make sure I had my docket correct. All right, we'll set this on March 23rd at 9 a.m. for docket call. So Mr. Stevenson.
Yes, sir.
All right, there you go. So Mr. Stevenson, you'll be ordered back before the court. If you're going to appear in Mr. Austin's office that day, then we'll do the same. Otherwise, if you're going to appear via Zoom, he will have that Zoom ID number for you if you'll stay in contact with him. You understand? All right, you're free to go.
Thank you, sir. Thank you, Judge. May I be
Thank you,
of
Mr.
assistance?
Austin. Yes, sir. Thank you, Mr. Austin. Appreciate it.
Thank you, Judge.
All right, let's see here. Mr. Gimbel, I think I have. Let me try to bring Sable Burgess in. Give her just a moment to connect to audio. All right, Ms. Burgess, I prompted you to unmute your device.
Yeah, I'm sorry about that.
No problem. All right, Ms. Burgess, can you see and hear me okay?
Yes, sir.
All right, and your attorney, Mr. Gimbel, is also present in our hearing, along with several other attorneys, but if you need to see him, you can move left or right on your device, okay?
Okay.
All right, Mr. Gimbel, this is cause number CR 2419, State versus Sable Marie Burgess, and we are set for arraignment today. Have you had an opportunity to go over the indictment with your client?
Yes, I have, Your Honor. And this is another case that I believe belonged to Danny Cox that Ms. Heisel extended an offer yesterday. And I've explained the purpose of this arraignment hearing to Ms. Burgess, but she is in agreement and is willing to accept the offer from the state in this matter. I believe we could resolve this. We can just get reset and set it for a plea, Your Honor.
Okay, well, let's go ahead and, are you going to waive the formal requirements of arraignment? We need to go ahead and do that before we set her for plea. So is her name spelled correctly in the indictment?
It is, Your Honor.
And she understands what she's been charged with?
Yes, she does.
And does she waive the formal reading of the indictment?
Yes, we do, Your Honor.
Okay. And for purposes of arraignment, does she enter a plea of not guilty before the court today?
Yes, Your Honor.
All right. And so, Ms. Burgess, the court's going to enter your plea of not guilty for purposes of today's hearing, which is just an arraignment. I understand the announcement that you've made through your attorney, Mr. Gimbel, is that you do want to accept the state's offer. So what we'll do is we will set this for plea. How long do you think you need on that, Mr. Gimbel? Do you March 3rd? Do you believe that's enough time to get it done?
I would be available March 23rd. Have plenty of time to resolve and acquire the paperwork. And
there's no issue with restitution or anything like that could delay it. Is that correct?
I don't believe so, Your Honor.
Okay. All right. Then, Ms. Burgess, the court's going to set you to enter your plea before the court on March 23rd at 9 a.m. You will stay in contact with Mr. Gimbel, and he will walk you through the process on how to complete the paperwork, and you will appear via Zoom that day unless Mr. Gimbel or the court directs you otherwise. And Mr. Gimbel, if you need Ms. Burgess to appear at the courthouse, she can appear here to help execute paperwork in the court video conference room.
That sounds good, Your Honor.
All right, Ms. Burgess, you are free to go.
Thank you, sir. Have a good day.
You too. All right, and Carl Klump, I do now. Sorry, he is here now. Let's see. Snuck in on me. While Mr. Klump is connecting to audio, give him just a moment. Mr. Steele, I'll call you next. Go ahead and while he's trying to connect here, I'm gonna go ahead and bring your clients in, Mr. Steele. I'm gonna bring all of them in so that if we have any issues, they can try to work those out while we move on. So at this time, I'm gonna bring in Mr. Watkins, Ms. McCoy, and Ms. Marshall. All right, Mr. Klump, can you unmute your device? There you go. Can you see and hear me okay?
Yes, sir.
All right, let me get back to your case here. This is cause number CR 20-294, State versus Carl Gene Klump. Mr. Klump, If you can't see Mr. Gimbel, I can assure you he's in our online hearing today. If you want to see him, you may be able to move left or right. If you're wearing a hat and sunglasses, I need you to take those off for me, please, sir. Thank you. All right, Mr. Gimbel, we are set for pretrial today. Mr. Clump's case, go ahead.
Well, we have no pretrial matters at this time, Your Honor. We just request to, and we have received all the discovery material in the matter and a plea offer, and we would just request being put on the trial docket.
Okay. You want me to set it for docket call?
Yes, Your Honor.
Okay. Court will set Mr. Clump then for docket call on March 23rd. And on that date, as you're aware, Mr. Gimbel, I will expect Mr. Clump that day to indicate to the court whether he's going to resolve his case by plea agreement or if he's going to be asking the court to set him for a bench trial or a jury trial to resolve his case.
We'll be prepared, Judge.
All right. And Mr. Clump, do you understand?
Yes, sir.
All right, Mr. Clump, you're due back before the court on March 23rd at 9 a.m. via Zoom as well. All right, you're free to.
Thank you.
You're welcome.
And Your Honor, that completes all I have this morning. We'll see you this afternoon if I can be excused.
Yes, thank you, Mr. Gimbel. Appreciate you. All right, Mr. Steele. Appreciate your patience. Let's go with Ms. McCoy here. Ms. McCoy, I'm going to ask you to unmute your device. All right, Ms. McCoy, can you see and hear me okay?
Yes, sir.
All right, and your attorney, Mr. Kyle Steele, is present in our hearing. If you can't see him, you may have to move left or right on your device. This is cause number CR 20-262, State versus Stormy Ray McCoy, and we're set for docket call today. Any announcement, Mr. Steele?
Yeah, Judge, I talked to the state yesterday. I think we have an agreement to plead. We can set this for a plea, Judge.
Okay. Can we execute that plea on March 23rd? Are you available that day, Mr. Steele?
It'll work for me, Judge.
All right, Ms. McCoy, we're going to order you back before the court on March 23rd. You're going to appear via Zoom that day. You need to stay in contact with Mr. Steele, and he's going to walk you through the process of how to execute all your plea papers. And Mr. Steele, if you need Ms. McCoy to appear in the courthouse, she can do so in the video conference room if that assists her in getting her paperwork done.
Thank you, Judge.
All right, Ms. McCoy, you're free to go. We'll see you back on March 23rd via Zoom unless Mr. Steele or the court directs you otherwise.
Okay, thank you.
You're welcome. You're free to go. All right, Ms. Marshall, I'm going to prompt you to unmute. All right, Ms. Marshall, can you see and hear me? Okay? All right, can you see and hear me? Okay? All right. This is cause number CR20. This is cause number CR 20-178, State versus Kimberly Dawn Marshall. We're set for docket call today. Any announcement, Mr. Steele?
Same announcement, Judge. I think we have a plea worked out on this one. We could do March 23rd again if that works for the court.
Okay. Court sets Ms. Marshall then to enter her plea before the court on March 23rd. Ms. Marshall, same thing I told Ms. McCoy, stay in contact with Mr. Steele, and he's going to walk you through how to enter your plea and get all the plea paperwork done. You'll appear via Zoom that day also, unless the court or Mr. Steele directs you otherwise.
Yes, sir.
All right, you're free to go.
Thank you.
You're welcome. All right, let me find Mr. Watkins here. Mr. Watkins, if you'll go ahead and turn on your device and unmute. All right, I'm going to prompt you to unmute. To receive a prompt. Try that again. All right, Mr. Watkins, can you see and hear me okay?
Yes, sir.
All right. Your attorney, Mr. Steele, is also present in our hearing. This is cause number CR 2201, State versus Michael Watkins, set for docket call. Mr. Steele, go ahead.
Judge, we're not miles apart, but we're still don't really have an agreement on this one. I do have the discovery. I've talked to the state a couple of times. I was going to send the state some materials. We were going to ask for one more docket call, and I don't think the state opposes that.
That's correct, Your Honor. He's Mr. Steele referred to some information that I might find interesting regarding this case. And we would not be opposed to an additional docket call in this case.
Okay. I'll tell you that we've had this case on docket call since November of last year. So this will be the very final docket call. Today's the fourth time we've been present on a hearing like this. And I think, Mr. Steele, you haven't been here the whole time, but Mr. Watkins has.
That's right, Judge. I'm relatively new on this case, but you're right. That's right.
So I'm gonna grant that for you, Mr. Steele, because you haven't been here. But I'm gonna tell your client, Mr. Watkins, this will be the final docket call that you have on March 23rd. If there's no resolution to your case, of course, just going to put you on a trial docket, and there will not be an opportunity to plea bargain after that. Do you understand?
Yes, Judge.
All right. So you're due back before the court on March 23rd at 9 a.m. via Zoom for docket call. Stay in contact with your bondsman, stay in contact with Mr. Steele, and you're free to go.
Thank you.
Is that all you have today, Mr. Steele?
Yeah, Judge. Did you sign on Cole?
I did. Let's see if Kobe Cole is there. Let me go ahead and bring him in and we'll tell him. I'm sure you want that on YouTube anyway, right?
Blind squirrel finds one every now and then. I can be in contact with Mr. Cole.
Well, I believe he's coming in just a moment.
I can hear you. Can you hear me?
Yes, Mr. Cole. Good. All right. This is cause number CR 20-208, State versus Kobe Shane Cole. Mr. Cole, Mr. Steele, your attorney is present in our hearing today. Court received a motion to dismiss filed by the state, and the court granted that yesterday. So your case has been dismissed and you are free to go, sir.
Thank you, sir.
You're welcome. Have a good day.
You too.
Thank you, Judge. That's all I have today. May I be excused?
Yes. Thank you, Mr. Steele. Appreciate your patience.
Thank you. Have a good day.
All right, Mr. Stevens, let me see who we have for you. Let me try to bring in. Oh, I'm sorry. Let's see. Mr. White, I'm going to go ahead and bring yours in at the same time. But I'm also going to try to bring in Miss Leslie Gibson for Mr. Stevens. Someone will be with you in just a moment. Stay where you're at. I'm also going to try to bring in Eric Atkinson. Terrible feedback. Are everyone else hearing that?
Yes, Judge. It appears Mr. Klump is still in and that his microphone is on. That may be where we're getting that feedback.
Thank you, Ms. Heisel. All right, Ms. Gibson, I'm going to ask you to unmute. You'll just click that. There we go. All right, Mr. Stevens, this is cause number CR 2249, State versus Leslie Denise Gibson, and we are set for docket call today. Ms. Gibson, your attorney, Mr. Stevens, is present. If you can't see him, you may have to swipe left or right on your device. Go ahead, Mr. Stevens.
Your Honor, we still haven't reached an agreement with the state on this case. I believe we're going to, but as we speak, we have not yet.
Tell me kind of where we're at on things, on whether I should reset it. If there's not going to be an agreement, then I think we should go ahead and put it on the trial docket.
Well, I hate to go the trial docket and then lose our right to be able to negotiate. I think we're just a few months apart, Your Honor, to be honest with you. If you could afford us one more docket call, I think we'll either resolve it or it will go to the trial docket for sure.
Can I say something?
No, I want your attorney to speak for you, okay? So
I'm not Miss Gibson.
hang on, let me get back here. Oh, you're not? Okay, what's your name?
My name is Misty Munn.
Oh, I know. I know. I haven't called your case yet, Ms. Munn.
Okay.
But Ms. Gibson is present in our hearing. So I'm going to mute you. I'm going to mute you and I'll unmute you at the right time.
Okay.
All right. All right, today is the first setting for docket call, Mr. Stevens. So if there's no objection by the state, court would grant an additional docket call to see if there can be an agreement reached.
I appreciate that, Your Honor.
Is there any objection by the state?
No, Your Honor.
All right, court will set Ms. Gibson for an additional docket call on March 23rd. And Ms. Gibson, what the court's going to expect is for you and the state to negotiate. And if there can be a resolution, then let's reach one. If there's not going to be a resolution, then you'll tell me, you and your attorney will tell me on March 23rd. And if there is no agreement, then the court's just going to put you on the trial docket and we'll give you a trial and we'll see how things go.
Okay.
You understand? Okay. So make sure you're in contact with your bondsman and your attorney, and we'll see you back via Zoom on March 23rd, unless you're told otherwise by your attorney or the court. All right. So you're free to go.
Okay. Thank you.
I'll be calling you the next day or two, Leslie. Okay.
Okay.
All right. Have a good day. All right. Mr. Williams, I'm going to prompt you to unmute. So on that computer, you should see a button there. It says unmute. Right there. Just thank you, sir. All right. Can you see and hear me okay, Mr. Williams?
Yes, sir.
All right. Mr. Stevens, this is cause number CR 2372, State versus Leonard Marshall Williams, and we're set for arraignment. You have not had an opportunity to go over the indictment with your client. Is that correct?
That is correct, Your Honor. I have not.
All right. Give me a moment and we'll pull this up. And Mr. Williams, you were previously in the Kaufman County Jail. Is that correct?
Yes, sir.
Okay. Give me just a moment and I will pull up your case. All right, Mr. Stevens, what I'm going to do is we also have Mr. Atkinson, who's not quite connected. I'm going to move you and Mr. Atkinson and Mr. Williams into an attorney breakout room. Do you have a copy of the indictment with you, Mr. Stevens, that you can discuss?
I do not, Your Honor. The discovery hasn't been loaded yet.
Oh, you don't have discovery at all yet?
No, sir.
Okay. Well, all right, Mr. Williams, can you see that document on your screen?
Yeah, I can see it. It's kind of wide, but I see it.
It's kind of what?
It's wide. I mean, like, I can see it.
Like it's too big?
Yes, sir.
All right, let me see if I can make that smaller for you. Is this better?
Yes, sir.
Okay. All right, Mr. Williams, I'm gonna give you an opportunity. I want you to take just a moment. And do you read, write, and speak English?
Yes, sir.
Okay, I'm gonna give you a moment to review this document and tell me when you need me to scroll down on the page, okay?
Can you scroll down? All right. Yes. Yeah, I read.
Okay. All right, Mr. Williams, is your name spelled correctly in this document?
Yes.
And do you understand that you've been charged with possession of a, let's see, possession of a controlled substance with intent to deliver? You understand that?
You said it's a possession charge?
It says that you did then and there knowingly possess with intent to deliver a controlled substance, namely fentanyl, in an amount of 4 grams or more, but less than 200 grams. Do you understand that that's what you're accused of?
Yeah, I understand. Can I ask you where the maintain delivery charge comes from a possession? I ain't got charged for possession.
Let's just you just answer my questions, okay? And you and Mr. Stevens, your attorney, you can discuss further what these legal documents mean and these terms, okay? Right now, my job today in the arraignment is to affix your identity, to make sure that you are Leonard Williams, to make sure that you understand what you've been charged with, and then to find out how you intend to plead to this charge, okay? So right now, you understand that you've been charged with the first-degree felony offense of possession of a controlled substance with intent to deliver fentanyl in an amount of 4 grams or less. I'm sorry, 4 grams or more, but less than 200 grams. Do you understand that?
Yes, sir.
Do you understand also that the state has alleged that you have been convicted in what is seen in enhancement paragraph 1 and enhancement paragraph 2, in which they are wanting to prove to the court to elevate your range of punishment in this case to habitual felony offender status with a range of punishment of not less than 25 years or more than life imprisonment in the Texas Department of Public Safety. I'm sorry, the Texas Department of Criminal Justice Institutional Division, and a fine. Actually, I'm not sure that there is a fine on a habitual, but you understand that charge?
Yeah, I understand it, but I'm charged 20 years old, but I understand.
Okay. And so, Mr. Stevens, at this time, how would your client like to enter his plea to
Your Honor,
the main paragraph and then also to the enhancement paragraphs?
yes, sir, Your Honor. We will waive reading of the indictment in open court. We will enter a plea of not guilty to the primary offense. We'll enter pleas of not true to the enhancement paragraph.
Okay. All right. So the court will enter Mr. Williams' plea of not guilty into the record and pleas of not true to the enhancement paragraphs. And we will set this for a pretrial hearing. Are you available for pretrial on March 23rd, Mr.
Yes,
Stevens?
yes.
All right. Court sets pretrial March 23rd. Mr. Williams, you'll appear via Zoom again that day. Need to stay in contact with your attorney, Mr. Stevens. If you cannot appear via Zoom, you can appear at the courthouse like you've done today in the video conference room. Do you understand?
Yes, sir.
And Mr. Williams, have you gone over your conditions of pretrial release at all?
No, I'm supposed to pay, I guess, for the lawyer. I didn't know about the pretrial.
Okay. What I'm going to have you do is after the hearing's over, I'm going to have you have a seat in the hallway and a member of my probation department will come and speak to you about that.
Yes, yes, sir.
All right. So we'll see you back on March 23rd. Stay in contact with Mr. Stevens. Do you have his contact information?
Yes, sir.
Okay. We'll see you back on March 23rd via Zoom. Have a seat in the hallway and Ms. Burns from the probation department will be with you shortly.
Yes, sir. Thank you.
You're welcome.
And Mr. Stevens, I have updated the discovery portal, so you should now have discovery. It was in there. I just didn't click the magic button.
Okay. All right. Thanks.
All right, and for whatever reason, Mr. Stevens, I can't get Mr. Atkinson to, maybe he's connecting the
I
video.
know that.
Looks like
I know he's trying to get on.
Looks like he may be trying to connect to audio. While we're waiting on that, Mr. White, are you ready on Ms. Munn?
Yes, Your Honor.
All right, this is cause number CR 2350, State versus Misty LaDawn Munn.
That's correct, Your Honor. This pretrial, I filed the 3 motions I normally file. I don't believe there's any opposition by the state. Haven't had an opportunity to speak with the state concerning any form of negotiations. I believe that we could be able to get that done within the next month, though.
Correct me if I'm wrong, but there are no contested motions, correct?
No contested motions. That's correct. That I'm aware of.
Judge, state has no objections to the standard motions filed by the defense in this case.
Okay. Are you available on March 23rd, Mr. White?
Yes, I am, Your Honor.
All right, court will set Ms. Munn to appear on docket call on March 23rd at 9 a.m. Ms. Munn, you'll appear via Zoom that day. I'm sorry, Ms. Munn, you'll appear via Zoom that day unless you are directed otherwise by the court or your attorney. Do you understand? And I'm going to ask you to unmute. Now you can unmute.
Okay, yes, sir.
All right, so on March 23rd, you'll appear via Zoom again, and Mr. White will have that Zoom ID number for you. If you can't get it from Mr. White, then you can always contact the court or your bondsman.
Okay.
All right, so Ms. Munn, make sure you stay in contact with everyone that you're ordered to stay in contact with, your bondsman, your attorney, and your pretrial release officer, and you're free to go.
Okay, thank you.
You're welcome. All right, is that all you have today, Mr. White?
I believe so, Your Honor.
All right, you're free to go.
Thank you. Okay, how do I get off this?
All right, Mr. Ashmore, let's see if I can bring in Grace Fowler. All right, Ms. Fowler, I'm going to ask you to unmute your device.
Can you hear me okay?
Yes, I can hear you now. Can you see and hear me okay?
Yes, sir.
All right, Ms. Fowler, your attorney, Mr. Ashmore, is also present with us today. If you can't see him, you may have to move left or right on your phone. This is cause number CR 20-333 and 334, State versus Grace and Fowler. We're set for pretrial today, Mr. Ashmore.
We are, Judge. Good morning. And the only motion I have filed is a motion for leave to file additional pretrials if we discover something down the road. We've been given full discovery. This is a first and second degree felony charge with a 5 to 99 punishment range. And I've been negotiating with the state of Texas. Ms. Heisel's office, Ms. Curry and Ms. Heisel have extended my client an offer of 35 years. They have reduced that to 20 years concurrent on both sentences. I've talked to my client about that, and she's just asking this to be reset to a docket call. There's some information she believes we can get that might impact those plea negotiations. But essentially, I don't see any contested pretrial motions to come unless we discover something later, you know, like a medical record that we didn't have. But so I just filed that placeholder, and I'm asking the state not to oppose that. I do not anticipate any motions to come, but we just need that additional docket call to see if we can resolve this without trial, Your Honor.
All right, court will set Ms. Fowler then for docket call. Are you available on March 23rd?
Yes, sir.
Yes, Judge. I think
You are, Ms. Fowler. How about you, Mr. Ashmore?
I think I'm already there that day, Judge, and I'm just going to double check 1 second if I may. And hopefully it'll be in the real and not on TV.
That would be kind of nice.
Yes, Judge, I'm there already. So I'll see you on the 23rd.
All right, docket call set on March 23rd. In each case, if we're not back in person on that date, then you'll appear via Zoom again, Ms. Fowler. Mr. Ashmore will have that Zoom ID number for you. Stay in contact with him, your bondsman, and your pretrial release officer. Do you understand?
Yes, sir, I do. Thank you.
All right, you're free to go.
Thank you for the additional time, sir.
You're welcome.
I think
right,
that's it for me, Your Honor.
Thank you, Mr. Ashmore. Appreciate your patience today.
I know I'm glad today went better than last time. Thank you, Judge.
You're welcome. We'll see you.
See you soon.
Mr. Atkinson, I'm going to prompt you to unmute your device. There you go. All right, Mr. Stevens. Mr. Stevens, your attorney is present with us in court. If you can't see him, you may have to move left or right on your device, but he is here. This is cause number CR 20147, State versus Eric Ephraim Atkinson, and we're set for docket call today, Mr. Stevens.
We are, Your Honor, and I think that we have worked out an agreement. Mr. Atkinson, let me tell you this. After you and I spoke this morning, I got with the prosecutor, and she agreed to the 6 months that you were wanting. And so with that being said, Your Honor, we'd like to sit for a plea.
All right. Can we do this plea on March 23rd?
Yes, sir.
And will this be a plea to time?
Yes, sir.
All right. So let's do this. Let's set that for March 23rd at 1:30 out at the Van Zandt County Justice Center. And then
yes, sir.
You can just go into custody that day at the conclusion of the hearing.
Your Honor, wait just a second. Let me look at something. I think I am committed the 23rd in the afternoon. Yes, sir. I've got 4 cases set that afternoon and 392nd.
You want to just cancel all those?
Sure. Why not?
Is that Judge McKee?
It is, Your Honor. Yes,
he
sir.
won't mind. I know him. He's a great guy.
Yeah, he probably wouldn't mind as many cases as he has.
I'll just call him right now.
Hey, that'll work.
What
but
about,
I mean, if we could do that maybe at like 3 o'clock in the afternoon, that would get me time to do my Zoom and get over there.
What about the 25th, 2 days later?
I'm back in his court again, Judge. On 4 cases.
Wow, you got a favorite judge, I can tell. All right. All right. We'll keep it on the 23rd, and we'll just set it at 3 p.m. We'll set it.
That'll be great. I'll get there as fast as I can, Your Honor.
So, Mr. Atkinson, we'll have you come back on March 23rd in the afternoon at 3 p.m. and you'll report to the Justice Center, to the jail. All right. So you don't have to be there until 3. Okay.
All right. Yeah. Thank you.
All right. So we'll see you back on March 23rd at 3 p.m. and you're free to go.
Eric, I'm fixing to call you with the details.
All right. Thank you, Mr. Atkinson. Thank you. Is that all you have today, Mr. Stevens?
Yes, it is.
All right. I appreciate yes, I appreciate your patience and let me try to work down and get to you and handle all these tech issues. So sorry about the delay.
No problem. Have a good evening. Thanks.
Right. Yeah. Tell Judge McKee, your favorite judge, I said hello.
Hey, I'll do it, Judge.
All right. Bye-bye.
See you.
All right. Let me bring in Mr. Knoll. All right, Mr. Covey, we're going to be with you in just a moment. All right, so just hold what you got. Keep your phone real still and give me just a few minutes. Your attorney's getting logged in here. Mr. Knoll, can you hear me? Mr. Knoll, can you hear me? I can't hear you. All right, while Mr. Knoll's getting set up, Ms. Rankin, can you see and hear me okay? I'm going to ask you to unmute. I'm going to prompt you on your device. All right, there you go. Can you see and hear me okay, Ms. Rankin?
Yes, sir.
All right, Ms. Rankin, I'm Judge Chris Martin, and you're in the 294th District Court. Ms. Rankin, I see here that you've been charged with indictment or by indictment with possession of a controlled substance in penalty group 1 gram to 4 grams. Do you intend to hire an attorney to represent you in this matter?
Yes.
And do you know who you're going to hire and when you're going to have them hired?
I have an idea. I have a couple, 2 different lawyers that I've talked to. I just haven't hired them yet, or I haven't hired either or one of them. If you could just maybe give me a week and I can get that done.
Tell me who have you spoken with?
It was Randall. I gotta look on my paper. Just if you want to give me 1 second.
Go ahead. That's fine.
Sorry, I know I have them right here. Hold on, just give me 1 second. It was 2 of them that I had wrote down. Okay, I know it was Randall. I don't remember his. As soon as I find it, I will let you know. But another one of them is Dunn. Dunn and Dunn.
I'm not sure if the Dunns do much criminal work, but you can certainly speak with them. So if I reset you for at least a week, are you confident that you can have someone hired?
Yes.
And you understand the seriousness of this charge against you?
Yes, I do.
All right, and you understand the range of punishment. If you were convicted of this, Ms. Rankin, and sentenced by a jury, you could be sentenced up to 10 years in prison.
Yes, I do.
Okay. All right, let me look at my docket real quick. All right, Ms. Rankin, I'm going to give you until March 9th. So I'm going to order you back March 9th at 9 a.m. and I'll expect you to have an attorney with you.
Okay.
Okay?
Yes, sir.
All right, so make sure you stay in contact with your bondsman as well. And your bondsman will have the Zoom ID number, or you can contact the court as well to get the Zoom ID number.
Okay, thank you.
All right, you're free to go.
Thank you. Bye-bye.
This the first one or second one?
Second. Can you hear us now, Judge?
I can hear you now.
Okay.
Good morning. Good morning, Mr. Knoll.
Switch computers.
Who do you have with you immediately to your left?
This is Mason Foshi, Judge. He's on page, I believe it's page 3.
All right. All right, Mr. Foshi, this is cause number CR 20247. And it looks like we're going to enter a plea today. Is that correct, Mr. Knoll?
It is, Your Honor.
All right, I've got the plea paperwork with me. Mr. Foshi, I'm going to have you raise your right hand so I can place you under oath. And can you just slide over to your right just a little bit?
Yes, sir.
More important than I see you than Mr. Knoll. I see him enough anyway, you know.
Yes, sir.
Mr. Foshi, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you put your hand down. Mr. Foshi, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Knoll. Do you feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've reviewed and signed today that you do not understand?
No, sir.
All right, Mr. Knoll, do you believe Mr. Foshi to be competent today?
I believe he is, Your Honor.
And you've explained to him his legal and constitutional rights?
I have, Your Honor.
Right, and it appears that Mr. Foshi will be pleading guilty today to the third-degree felony offense of possession of a controlled substance in penalty group 1, less than 1 gram, or greater than or equal to 1 gram, but less than 4 grams. And in exchange for that plea of guilt, the state's going to be recommending to the court that Mr. Foshi be convicted of that offense, that he be sentenced to 5 years in TDCJ, but the state's asking the court to suspend that sentence and place him on community supervision for 5 years, assess a $2,500 fine, $180 restitution, and also recommending that the court dismiss several cases. In addition, there's a weapon forfeiture, reimbursement fees of $535, court costs of $290. Does that sound correct, Mr. Knoll?
It does, Your Honor. I think there's actually also a state jail level PCS case in there that's 1245.
Yes, I see state jail, an unfiled, unindicted PCS less than 1 gram, misdemeanor unlawful carrying of a weapon, actually 2 misdemeanor unlawful carryings of a weapon, and a weapon forfeiture.
Correct.
Okay. All right, Mr. Foshi, the range of punishment for a third-degree felony offense is confinement of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice Institutional Division, and a fine not to exceed $10,000. Do you understand that if you are convicted of this offense and sentenced to prison, you could be sentenced anywhere from 2 years to 10 years? You understand that?
Yes, sir.
Now, your plea agreement says that you're going to be guilty, and the state's going to recommend that your maximum punishment be 5 years in prison if you're unsuccessful on probation. You understand that?
Yes, sir.
All right. So, Mr. Foshi, at this time, how do you plead to the charge of possession of a controlled substance in penalty group 1, greater than or equal to 1 gram but less than 4 grams?
Guilty.
And Mr. Foshi, are you pleading guilty because you are guilty of that offense?
Yes, sir.
Has anyone threatened you or forced you or pressured you to plead guilty to that offense?
No, sir.
All right, court will accept the defendant's plea of guilt. Mr. Knoll, is there any objection to State's Exhibit 1?
No, Your Honor.
All right, State's Exhibit 1, stipulation of evidence is admitted. And the court takes judicial notice of Mr. Foshi's judicial confession. Is there anything further from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Take just a moment and review your evidence, Mr. Foshi.
over there. We got it jammed up.
All right, based on the court's review of the evidence, the court will find that there is sufficient evidence to convict Mr. Foshi of this offense. Court will follow the plea agreement in this case. Court hereby convicts Mason Walker Foshi of this offense, assesses his punishment at 5 years confinement in the Texas Department of Criminal Justice Institutional Division. Court will suspend that sentence and place the defendant on 5 years community supervision. Court assesses a $2,500 fine. Orders Mr. Foshi to pay $180 restitution, $535 in reimbursement fees, $290 in court costs. The court dismisses under section 1245, F19 572, possession of controlled substance, penalty group 1, less than 1 gram, unlawful carrying of a weapon, M19 718, and unlawful carrying of a weapon, M20 24. Court also orders the forfeiture of the weapons seized in this case, namely a Glock 17 9mm serial number AX604, and a Glock 42 serial number ACEL712. Mr. Foshi, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they carry out the terms and conditions of your sentence. Mr. Foshi, do you understand? Have you ever been on probation before?
No, sir.
All right, so probation requires maturity, accountability, and responsibility. You're going to be given an opportunity to stay out of prison and to serve your sentence while being in the community. If you violate your community supervision, if you test positive for alcohol, you test positive for any drugs, any illegal substances, if you don't do your community service, if you don't pay your fees, if you don't do all the things that are required of you, then the court, if you're brought back before the court's going to decide whether you go to prison. You understand that?
Yes, sir.
How old are you, Mr. Foshi?
21.
21. You're all to be talking to a district judge about potentially spending a portion of your life incarcerated in a prison.
Sir.
So you have an opportunity here that Mr. has worked with the state to give you. And I hope that for your sake and for my sake that you and I don't cross paths again. Hope the next time I see your name, it's on a document that says that Mr. Foshi's done everything that he's supposed to do, and we want to let him off probation. That's what I'm hoping for. You understand?
Thank you, sir.
But if it's not, if you're brought back before me, all right, I've done my end of the deal. I've reviewed the agreement. I've approved it. I'm going to give you the opportunity. The ball's back in your court. If you run that ball out of bounds, that's on you.
Yes, sir.
All right, I want you to step out in the hallway, and the probation department will be by to speak with you shortly, okay? So just have a seat out on the benches.
Thank you, sir. Thank you.
You're welcome.
Okay, Mr. Lodge. You'll come sit by Mr. Hill. Now, are you gonna make a payment plan?
Sit down.
All right, Mr. Knoll, is this Mr. Lassiter?
It is, Your Honor.
All right. This is cause number CR 2058. Ms. Tabraham? Is Ms. Tabraham in? Can you ask them to close their doors?
Yeah, yes, close the doors. Apparently he's picking up too much noise. I think we've got it, Judge.
Is this,
I can't hear him now. He's talking to us. Well, maybe he's not talking.
Yeah, I'm not talking to you right now, Mr. Knoll.
Okay, we're good.
All right, this is CR 20258, State versus Jonathan Russell Lassiter. Mr. Lassiter, raise your right hand so I can place you under oath, sir. Mr. Lassiter, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you put your hand down. You are Jonathan Russell Lassiter, is that correct?
Yes, sir.
Mr. Lassiter, are you a United States citizen?
Yes. Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes.
What have you been diagnosed with?
Anxiety, depression.
Okay. Are you currently undergoing any treatment or medication for those?
Yes. Judge, the court may note in a part of our papers, he's to start working through the Andrews Center system on some of those issues and get on appropriate medications. But currently is not on any medication.
All right. Thank you, Mr. Knoll. And Mr. Lassiter, do you feel like you have a rational understanding of what's going on here today?
Yes, sir.
All right. And do you feel like you've had enough time to speak with your attorney, Mr. Knoll, about your case and have all of your legal questions answered?
Yes.
Is there anything about your case that you don't understand?
No, sir.
All right. And Mr. Knoll, do you believe him to be competent today in light of his mental health?
Judge, I've never seen any mental health issues at all in the times that we've discussed the case.
And you've explained to him his legal and constitutional rights?
I have, Your Honor.
All right. And you feel like he understands everything that's going on today?
I believe that he does.
All right, Mr. Lassiter, you're charged by indictment with the third-degree felony offense of driving while intoxicated, third or more, that carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice. Do you understand that full range of punishment?
Yes, sir.
It appears to me that there's a plea agreement between you and the state today wherein you're going to plead guilty to that offense. And then the state's going to recommend that your sentence be set at 5 years confinement in TDC, but that sentence be suspended and you be placed on probation for a period of 5 years. You would also have a fine of $3,500 and $60 restitution and $535 reimbursement fee, $290 court cost. Do you understand that to be the plea agreement today?
Yes, sir.
All right, so Mr. Lassiter, I'm going to ask you at this time, how do you plead to the third-degree felony offense of driving while intoxicated, third or more offense?
I'm guilty. Guilty, sir.
And Mr. Lassiter, are you pleading guilty because you are guilty of committing that offense?
Yes, sir.
Has anyone threatened you or forced you or pressured you to plead guilty?
No, sir.
All right, court accepts the defendant's plea of guilt. Mr. Knoll, any objections to the admission of States 1, the stipulation of evidence?
No, Your Honor.
All right, States 1 is admitted into evidence and the court takes judicial notice of Mr. Lassiter's judicial confession. Is there anything further from the state?
No, Your Honor.
From the defense?
No, Your Honor.
I'm going to take just a moment to review the evidence. All right, based on the court's review of the evidence, I find that there is enough evidence to convict Mr. Lassiter of this offense. The court will follow the plea agreement in this case. The court convicts him of the offense of driving while intoxicated, third or more, assesses his punishment at 5 years confinement in the Texas Department of Criminal Justice Institutional Division. The court suspends that sentence, places him on community supervision for 5 years. Court assesses a fine in the amount of $3,500, restitution in the amount of $60, $290 court costs, and orders him to reimburse Van Zandt County for $535. Mr. Lassiter, you hereby remanded to the custody of the Van Zandt County Community Supervision Corrections Department so they can carry out the terms and conditions of your sentence. I want you to go have a seat in the hallway, and a member of my probation department will be by shortly to talk with you more, okay?
Yes, sir.
All right, thank you.
Thank you.
Meet with you out there. Judge, I also had a Michael Shane Covey.
Yes,
when
he's present. He's present with us.
in the courtroom.
Yes, looking
Okay,
at.
well, he's never checked in with me today, so,
Okay, well, give me just a moment. I'm gonna call this case. I gotta finish
okay.
paperwork and I'll be right with you.
Thank you, Judge.
All right, Mr. Knoll, do you not see Mr. Covey in your screen? He's been present during our pleas that we've done on your clients. You may.
I don't, but
You
if
may-
he's there,
I tell
I am.
you, listen for just a second. You may have to go up where it says view and click on view and change that to gallery view instead of speaker view. You'll change up in the top, it'll say view. Click that to gallery view and you should see him. It's probably on speaker view right now.
Okay, Judge, I've got it.
All right, you see him now? Okay, good. All right, this is cause number CR 20327, State versus Michael Shane Covey. We're set for pretrial today. And Mr. Covey, I don't know if you can see Mr. Knoll. I'm gonna also prompt you at this time to unmute your device. You should receive a, there you go. All right, can you see and hear me okay, Mr. Covey?
Yes, sir. Yes, sir, Your Honor.
All right, Mr. Knoll, any announcement on pretrial today?
Judge, on pretrial, I met actually with Ms. Heisel this morning early, 8:15, 8:20 or so. It appears that there is presently an unindicted potential third-degree felony, as I recall, involving Mr. Covey or Mr. Covey. We've discussed those issues. Ms. Heisel indicated she believed it would probably be indicted next month. So what we would like to do is pass this case until we determine what will happen exactly with the other case and dispose of both cases one way or the other at the same time, I hope.
Are there any contested pretrial issues in this case?
I don't believe so, Your Honor.
All right, then what I would do is set this for docket call, and then whenever the other case comes along, then I will consider resetting the docket call until they both get to the same level. All right, so Ms. Heisel, do you have any rough estimation on when that case may come before the court?
Judge, I've already reviewed that case. I do believe it's ready for indictment, but I know our grand jury dates are probably being rescheduled because of some conflicts. So if we could get a setting the first week of April, I believe that will give us sufficient time to both file that, get discovery to Mr. Knoll. I've already provided Mr. Knoll an offer in that case.
Mr. Knoll, are you available on April 1st?
Is that an actual setting or April Fools? Either way, if it's an actual setting, I'll be available.
I'm not going to tell you until the 1st.
Okay, that sounds good, Judge.
Yeah, we'll set you for docket call on April 1st at 9 a.m. Mr. Covey, you'll appear via Zoom again that day. You need to stay in contact with Mr. Knoll. He's going to have the Zoom ID number for you. All right.
Yes,
stay in contact with your bondsman and are you currently reporting to your pretrial release officer?
Yes, sir. I report this week.
Well, it's important that you stay in contact with your pretrial release officer. Make sure that you're complying with all your bail conditions. Okay.
Yes, sir. Yes, sir.
All right. Anything further, Mr. Knoll?
No, Your Honor. I believe that's all I have till this afternoon.
All right, gentlemen. We'll see you back on April 1st at 9 a.m. via Zoom for docket call.
Thank you, Judge.
You're welcome. Free to go. So I'm bringing in Mr. Manning. He's been appointed to Mr. Rosa. I'm going to bring both those in, except for arraignment. Mr. Manning?
Morning, Judge.
Can you see and hear me okay?
I can.
That's unfortunate for you.
Hey, at least I got my microphone working.
Amen. Amen. All right. I'm bringing in Miss, I don't know if it's Mr. or Miss Calixto Rosa. Calixto Rosa. There we go. He's not quite connected to audio yet. We'll give him just a minute.
Okay.
Hello?
Okay, Mr. Rosa, can you see and hear me okay?
Yes.
Okay. All right, Mr. Rosa, my name is Judge Chris Martin, and you are in the 294th District Court. If you can just kind of set your phone down and get it still, maybe set it up against something.
Not really. I've tried that.
Okay, just keep it still for me so there's not so much movement if you can. All right, and Mr. Jonathan Manning, an attorney, has been appointed on your case, and he is present in the hearing. If you can't see him, you may have to swipe left or right. If you want
Do you see me, Mr. Calixto? Mr. Rosa?
Yes.
Okay.
Okay. All right. Is it Calixto?
Yes, it is. Calixto. Yes, sir.
Okay. And your last name is Rosa?
Yes, sir.
All right, Mr. Rosa. All right. This is cause number CR-2409, and we're set for arraignment today on a third-degree felony offense of tampering or fabricating with physical evidence. Mr. Manning, have you had an opportunity to go over the indictment with your client at all?
I have not, Judge. We were going to try to get into a breakout room, but we were unable to do that. I have reviewed the indictment. If his name is spelled the same way that it is spelled on his Zoom ID, then his name is spelled correctly on the indictment. And Mr. Rosa, you understand you're being charged with a third-degree felony. Is that correct?
I'm not educated enough to know what the severity of that is.
Okay, so a third-degree felony comes with a range of punishment of 2 years to 10 years in a Texas Department of Criminal Justice, as well as a $10,000 fine.
So I'm looking at 2 years in jail?
2 years to 10 years is the range of punishment. Yes, sir. So that's what you're being charged with, right? Now that's at this point in time, our plea is going to be not guilty to the court. Do you understand that you're being charged with tampering, fabricating physical evidence with the intent to impair investigation?
And Mr. Manning, you said that y'all attempted to get into a breakout room?
Yes, Judge. Miss Abraham was going to place us in a breakout room, but it for some reason I popped up here first.
It wasn't. Okay, so this is an arraignment.
Hold on, Mr. Rosa. Hold on, just 1 second. I want to see if we get into a breakout room.
All right, so listen, this is what we're going to do. All right, I'm going to prompt you to join a breakout room, Mr. Manning and Mr. Rosa. Mr. Rosa, when the invitation comes your way, you're going to join that, and you and your attorney, Mr. Manning, are going to go into another room where no one else is going to be. And you and he will have the ability to talk about the case, talk about the charge. Mr. Manning can explain some of the legalities to you and the process of today's hearing, okay? And then once that is over, all right, when you and Mr. Manning have had enough time, then you're going to come back into the main courtroom with me, and then we're going to move forward with the arraignment. Do you understand?
Your Honor, this is a huge charge, and I've never been charged with anything like this in my entire life. I am still, I've been really depressed about everything and all the situations that are coming, and very stressed with trying to pay the bondsman. And
I understand, Mr.
I'm from Miami. I've only been here like 2 years.
Mr. Rosa, listen, all right? Just listen to what I'm telling you to do, okay? This is very important. Today, the purpose of today's hearing is an arraignment, okay? All that means is I need to affix your identity, make sure that you are who you say you are. We've done that. Make sure that you understand what you're being charged with here in the state of Texas, okay? We're going to enter your plea of either guilty or not guilty today. You're going to speak with your attorney, Mr. Manning, all right? He's going to explain all of these things that you're telling me. You don't need to be telling me. You need to be telling Mr. Manning, your attorney. You need to be aware that the prosecutor who's alleging that you've committed a crime, she's present in this hearing today too. So anything that you say here in open court, she can use that, okay? So I'm going to send you to a breakout room, and you need to talk with Mr. Manning. Mr. Manning's an attorney and counselor, okay? What that means is he's going to counsel you on the law. He's going to answer your questions. You can tell him about your stress and about all these other things. He's going to be able to tell you about what you are facing legally and how this court process is going to work. He's going to walk you through that, all right? So I need you to defer to all your questions, defer to him, and let him advise you of the process, and then let him work with you going through this, okay? All right, so right now, all I need to know from you is, do you understand I'm about to prompt you to enter into another room on this computer, on your device, and it's just going to be you and Mr. Manning. Y'all spend some time talking about your questions. He's going to explain some things to you. When you get done, we're going to come back into the courtroom, and then I'm just going to go through this arraignment process, and then we're going to set you for another hearing. Do you understand that?
Yes, sir.
Okay, so just hold what you got. I'm going to prompt you to join a room, and when you get there, it's just going to be you and Mr. Manning. I'm not going to be there, and Ms. Heisel, the prosecutor, is not going to be there. And then when you get done, I'll bring you back in. So, Mr. Manning, when you get done, you just rejoin. And if Mr. Rosa needs help being brought back in, you let me know and I can do it, okay?
Yes, Judge.
All right, so I'm going to prompt y'all to join this room right now. And we'll just stand in recess until they come back. Except for, I'm a little upset Mr. Garcia is not here today. Daniel Garcia is no longer in Galveston County. He was released on February 8th.
Oh, man. Do we know when he will grace us with his presence next?
We do not. We do not. I'm wondering if Lone Star bail bonds, if they are in fact a bondsman, if perhaps they wouldn't call the court and give us some information before the bail bond gets forfeited.
Judge, off the top of my head, I don't know. Do you know who operates Lone Star?
I do not. I do not. Also, there's a couple of Jeff Wood's clients that are on today's docket. Wanted to make sure that you're aware of the waiver of arraignment on John Lapano. Waiver of arraignment filed. Court granted that, set pretrial on March 23rd. And he also had a Chad Darvin Thomas set for docket call, filed a motion for continuance. Court granted that and reset docket call until March 11th. I should be aware of that. I think that is everyone else except Mr. Rosa. My page 2, Christopher Hunley, did not have an attorney's name on it. If you have that on your docket, CR 2344 has hired Mr. Nolan White. They filed a waiver of arraignment, and pretrial was set March 23rd. So Ms. Taberham's going to go call Lone Star bail bonds, find out about Mr. Garcia. Oh, this afternoon? Oh, okay. And while I have you prosecutors, this afternoon, Mr. Wood also has Brian Scott Kronberger set for arraignment. They filed a waiver of arraignment. Court hasn't approved that yet, but I will be, and I will be setting pretrial for March 23rd.
Thank you, Judge.
He also has James Dale King filed a motion for continuance. Court granted that, set pretrial on March 11th. So that'll be 2 this afternoon. We won't be addressing. We'll just stand in recess until Mr. Manning and Mr. Rosa come back. Okay?
Yes, Your Honor.
All right, thanks. Are you ready, Mr. Manning?
We are, Judge.
All right. So you're going to be ready to, I'll tell you what, let me get the indictment pulled up for you. Will that help you?
Yes, Judge. I tried to show it to him over my side. I couldn't share screen, and the printed copy was unable to come through clearly enough.
Okay. Yeah, give me just a moment. I'll got it now.
In the future, it said the share screen was disabled by the host. In the future, that may be helpful if we get kicked out to a breakout room for arraignments.
Yeah, maybe remind me, because it's a default setting, because
Okay.
I don't want other people being able to share their screen, because I don't trust anybody else. All right, let's see here. You try to bring him back in and. All right, we are back on the record in CR 20-409, State versus Calixto Rosa. And at this time, Mr. Manning, I'm going to have displayed Mr. Rosa's indictment in this case for purposes of arraignment. Mr. Rosa, can you see that document on your phone?
Yes.
Okay. All right. Do you have any questions of him, Mr. Manning?
Judge, I've spelled out his name and discussed the charge. His name is spelled correctly. He understands the charge against him. And this time we're entering a plea of not guilty for purposes of arraignment.
All right. The court will enter Mr. Rosa's plea of not guilty into the record. We will set this matter for a pretrial hearing. Are you available on March 23rd, Mr. Manning?
Let me pull up my calendar real quick, Judge. Yes, Judge, it appears I am available.
Mr. Rosa, the court's going to order you to reappear before the court for a pretrial hearing in this case on March 23rd at 9 a.m. You'll appear via Zoom the same way that you have appeared today. You need to stay in contact with your attorney, Mr. Manning. He'll give you the Zoom ID for this hearing, but it'll be at 9 a.m. on the 23rd. Do you understand?
Yes, sir.
All right. You also need to stay in contact with your bondsman. They can also assist you in getting connected. Mr. Rosa, where do you live currently? Where do you
I live in Dallas and Duncanville.
Okay. And you need to, have you been in contact with the pretrial supervision office?
Is that the bondsman?
No. Okay. So what I'm going to do is, Mr. Manning, I'm going to ask that you contact the pretrial supervision office and share the information regarding his pretrial supervision conditions with him and see if we can't get that sent to him and get that signed. Mr. Rosa, do you have transportation?
Yes.
Okay. Mr. Rosa, what I'm going to do is I'm going to order you to appear at the pretrial supervision office here in Canton. All right?
Wait. Listen, I'm going through, Your Honor, I am going through it. I just filed a domestic violence case on my girlfriend. I left the house. I'm homeless right now, basically staying out of the way. I didn't press charges because of the situation. I wanted everything to calm down. And then also I have a case open on her. I just needed to find out.
Judge, I was unaware of any conditions of pretrial release. Those haven't been provided at this point in time, but if you'd like, you can send them over. I can discuss those with Mr. Rosa. If there's any discrepancies or need for accommodations, we'll contact the court on those.
What does that mean?
Mr. Rosa, what that means is you've requested a court-appointed attorney, all right? Mr. Manning is being paid by Van Zandt County to represent you. You've not paid a penny out of your pocket for his legal services. Is that correct?
Yes, sir.
All right. You're also on bond. That means you've paid a bondsman to get out of jail, haven't you?
Yes, sir.
All right. The court has appointed Mr. Manning, and the court is going to order you to reimburse the taxpayers of Van Zandt County for Mr. Manning. And you're going to do that through the pretrial release office. You're going to have conditions on your bond. You posted bond, you're out of jail, and now you're going to have conditions that say that you have to report, that you have to drug test, that you can't commit new offenses, that you're going to have to reimburse the county, that you're not going to be able to possess a firearm. There's going to be multiple conditions that you're going to have to comply with. And if you do not comply with those, the court's going to revoke your bail and put you back in jail. That's what that means. All right. So there's going to be conditions of pretrial release on your bail.
But what there wasn't any. But why would you put it on now?
I just told you, Mr. Rosa, you've not paid a red cent out of your pocket for Mr. Manning's legal fees. You are going to be required to reimburse Van Zandt County for the legal fees that Mr. Manning is going to bill the county. You understand? And in addition, you're going to drug test when I tell you to drug test. You're going to report when I tell you to report. You're not going to commit any new offenses. And it's my way of supervising you while you're on pretrial release until you get this case resolved. So I'm going to order you to report in Canton to the pretrial release department.
Oh, I live in Dallas.
Mr. Rosa, I don't care where you live. Am I supposed to just let you do whatever you want to do, Mr. Rosa? No. The answer is no. I don't want you to even try to answer that. You are going to report in Canton before 4 p.m. Today is Tuesday. I'm going to give you until Thursday. You're going to report down here in Canton. You're going to get in your car. You're going to drive your butt down here. You're going to report, and you're going to comply with all your pretrial release conditions. And if you don't, you don't. And I'm going to revoke your bail, and I'm going to put you back in jail. And then I'm going to bring you out from the jail anytime I want to see you. You understand? You're going to have to calm down and pull yourself together. How old are you, Mr. Rosa?
I'm calm, sir. I understand everything you're saying.
You're not calm. You're not calm. Answer my question. How old are you?
32.
32. Are you a grown man?
Still growing.
Then pull yourself together. Be an adult. Listen to what I'm telling you. Do what you're supposed to do. Work with your attorney. Stay out of jail and resolve your case. It's that simple. If you want to keep flailing around like a child every time I tell you something, then this case is going to be very difficult for you. Do you understand?
No worries. Sir, I've just been up for a lot of hours. I'm working a lot, so I'll see to it that I do everything you say.
Stay in contact with Mr. Manning. Mr. Manning, I'll have the pretrial release conditions sent over, but he's to report before 4 p.m. on Thursday to sign the conditions.
Yes, Judge. I've actually sent an email to Mr. Waddell requesting he contact me with those conditions and to discuss those.
All right, and then we're going to see you back in court on March 23rd at 9 a.m. You're free to go, Mr. Rosa. All right, I believe that is all of your cases, Mr. Manning, if you will stay for just a moment.
Yes, Judge.
Matter to take up with you. Mr. Garcia, the bondsman said they were unaware that he was out of custody. They're going to try to get him to zoom in the afternoon docket. And so I'm going to have his name called today, this morning, but hopefully he'll zoom in this afternoon. All right. So at this time, I'm going to stop our